On the slopes of Diamond Head. This is Kapiolani Community College. Kulia ika nu'u. Strive for the highest.
Aloha. Welcome to the legal environment of business, Business Law 200. I'm Ben Carroll. Well, we've been looking at the employment relationship. We talked about at will. We talked about some of the rights and responsibilities of both the employer and the employee. And we said today we're going to take a look at employment discrimination, so the laws that protect employees from discrimination of various types. But first, let's take a look at what we covered in our last session. Okay, so what does employment at will mean, and what are some of the exceptions to this doctrine? Okay, you recall employment at will means at choice, so to speak, so it's the choice of both the employer and the employee whether or not the employment relationship continues. So the idea being from common law that an employee can be dismissed or the relationship can end at any time for any reason or no reason. And we still use the term employment at will. However, there have been a lot of modifications to it over time. So it's no longer the very unequal relationship where an employer can fire an employee for any reason. So what are some of these exceptions? Well, a number of them have been put into place due to public policy, and they've been embedded in statutes. So certainly the topic of today's session when we talk about discrimination is covered, and you cannot refuse to hire or fire someone if they're a member of a protected class or status. In other words, you cannot hire or fire based on race, religion, gender, that sort of thing. There are a number of other requirements that, again, enforce public policy considerations, such as if you attempt to fire someone for exercising their right to vote or serving in the military or serving on a jury, then those are also protected by statute, as well as whistleblowing. In other words, public wants to encourage employees to report if the employer is committing illegal acts or dangerous acts, and so that kind of reporting is also protected if there's a retaliation, firing an employee for doing a public duty, so to speak. Okay. How do federal and state laws interact in the employment area, and how do we know which law we should follow? Okay, as we looked at, there are both federal statutes and state statutes, and very often they cover the same areas. For example, the Fair Labor Standards Act covers minimum wage, overtime, child labor, etc. And on the other side, the wage and hour law in our state and many states covers the same matters. Now remember that if a federal law sets a kind of a minimum, a state can provide more benefit. So a number of states have higher minimum wages for their state workers than is required by the federal minimum wage. And as we'll see today, we could also protect additional classes and provide additional benefits in our state law. So federal law kind of sets the floor, kind of the minimum that all states have to follow. And in general, if there are something more beneficial, that's the law we're going to follow. What's the government attempting to balance in workers' compensation law, and can a worker file a lawsuit for work-related injuries? Okay, you recall that workers' compensation is a scheme that's been put into place by the government, which in effect takes a number of types of injuries out of the tort system and puts them in their own system, which is the workers' compensation scheme. This is similar to what we've also done, we talked briefly about in the no-fault insurance. So we're taking something out of the tort system, and we think we can handle it better or more expeditiously or in some fashion in a better way by putting it in its own system. And that's the workers' compensation scheme. Now, what does it mean? It means that if you have an accidental injury in your work, in the course and scope of your employment, then your exclusive remedy is the workers' compensation law. So you do not sue your employer at that point. So you're trading the right to sue an employer for the right to have, in essence, guaranteed benefits of a certain level. Now, what have you given up? Well, you don't get the pain and suffering and that kind of thing, but you do get the right to get compensation, which in a lawsuit against your employer under common law might have been kind of iffy. Okay. Now, if you've seen the materials on the website, you probably have had a little thought about when you looked at the workers' compensation law. It's kind of interesting because they actually put a value, a money value, on your various body parts. So if you lose an eye, you get a certain amount of compensation and that sort of thing. And it's a little bit ghoulish, and certainly the rates are not such that you would voluntarily sell any of your body parts. Okay. How does the government help provide for worker income security and retirement? So a lot of our laws in this area came about during the Depression, when people were out of work and had no means of support. So we have a number of laws that cover that, some state, some federal. So we do have unemployment compensation, we have temporary disability insurance, and those types of things. Now, with respect to retirement, we rely on the government in a number of ways. Okay, so there's some direct payments by the government when you retire, and that's the Social Security retirement benefits. Social Security also provides some disability benefits to you or your family, and some death benefits. But this is very minimal. Again, this is kind of the floor. They also provide Medicare, which when you reach a certain age, and Medicaid if you are needy. So there are some other provisions there for people that need additional assistance even before they retire. Now, again, on retirement, what else is there? Well, formerly, a number of companies used to offer pension plans, and this is very, very much reduced now. Only a few companies offer, and some of the state government and the federal government still have retirement plans, such as the military. If you do happen to be in a company with a retirement plan, then the ERISA, Employees Retirement Income Security Act, will provide some protection of your rights with respect to that pension plan. And then finally, there's some encouragement to do individual savings for your retirement, and that's the IRA, Individual Retirement Account, 401k plans. And really all the government does for you here is they give you a tax break to encourage you to do that yourself. Okay, who are the parties to a collective bargaining agreement, and what are their responsibilities in reaching agreement? So collective bargaining, who is the collective? Well, that the collective means we've collected our employees together. So the employees are bargaining with the employer as a unit. So we also refer to these as labor management agreements. And again, the labor are the workers operating through their union. And on the other side is the management employer negotiating. What are the responsibilities? Well, you are not permitted to engage in unfair labor practices. We talked about some of those both on the employer side and the union side, and you need to bargain in good faith. So you're encouraged to resolve these things amicably. If not, of course, there are strikes, but again, there's a lot of regulation of how these can occur and what's proper and improper conduct. Okay, and the general evolution of our labor law in the United States, again, as we talked about, originally the labor union movement and this type of organizing led to a lot of violence. So there were deaths, there were a lot of antagonism going on. And so we looked at the four major laws that came into effect in the 30s through the 50s. And the idea here was to balance the rights and to provide for peaceful means of resolving this. So we had the National Labor Relations Board that would look at these things, and we also had the Federal Mediation and Conciliation Service. The whole idea being to take this out of the battle zone and to make it work better. So the first laws were actually to put into the law that bargaining collectively by unions is appropriate, is okay, it's legal. So we talked about what the employer couldn't do to the members trying to organize, and then kind of the pendulum swing. And so the next laws talked about, well, also when the union gets a certain amount of power, there appear to be some practices on that side that aren't fair. So they added some protection for the employers. And then in the final law, we looked at making sure that the union members themselves retain some freedom of choice about their association and had member rights, kind of a Bill of Rights for union members. Elections would be fair, their money would be taken care of, that sort of thing. So we're trying to strike the balance between both sides. Okay, well today we're going to get into the discrimination area, and we've hinted at it a little bit, we've talked about it a little bit, but we're going to look at the various laws that protect us in our employment from various types of discrimination. So we'll talk about the idea of protected classes, what a protected class is. We'll look again at both the federal and the state protections, and we've already kind of had a preview of this. So the state can provide more protection than what is provided federally, but cannot provide less. So again, we're setting a floor here. We'll talk about the Civil Rights Act, a major law in this area. We'll talk a little bit about sexual harassment, which is considered a form of sex discrimination. And then we'll end up with the Americans with Disability Act, which is another major law. It's been around now a little over 20 years, and that was another very major piece of legislation affecting discrimination, not only in the workplace, but in general. Okay, so full plate today. Okay, when we talk about discrimination, you can see here, this is Selma, Alabama, which you will probably recognize as where Martin Luther King marched quite a few years ago. And you can see the pool here says, white only. Okay. When we talk about discrimination and civil rights, we're talking about something much, much broader than employment, obviously. So we're looking at discrimination in various different arenas, not just employment. So there's quite a bit of material on the general civil rights movement and the development of the law on the website. So if that's something that you're not familiar with or you'd kind of like a refresher on, take a look at that. And you'll see a little bit about civil rights movement, Brown versus the Board of Education, about segregated education, and just kind of the general background of this area. Okay, again, discrimination covers public accommodations, the right to eat at a restaurant, to get a hotel room, covers the state and local government, covers employment, which is what we're going to spend our time talking about today, also covers housing, even covers public entities, so certain requirements of private entities in addition to the public accommodation side. So we'll be, again, focusing on employment, but again, recall that this is part of a much bigger picture. And some of it's hard to even, if you weren't around at that time, it's hard to even believe some of what went on. So I did show you the whites only slide. You'll see a number of other visuals and background on the website. So those of us that have been around a while and traveled on the mainland saw instances where there were different water fountains and different bathrooms. So there would be a restroom for men, women, and then a third restroom for colored. Same with water fountains, a white water fountain and a colored or Negro water fountain. So these things, again, are hard to believe. But even in Hawaii, for many years, one of our clubs, the Pacific Club, did not allow Asian members. Okay, so there's a lot there. And if you're not familiar with that background, that would be very useful for you to look at before you get into the employment side. Okay, so who are we attempting to protect? In other words, who is being discriminated against that we're attempting to protect? And we have the concept here of protected class. So that's a category of people or a population that has traditionally been subject to discrimination or has been underrepresented in employment or other aspects of life. So that's what we mean by a protected class. We also use the concept of suspect classification, which is essentially the same view. And what we mean by a suspect classification is this is the same categories, and the term means that we're looking very closely at them. If it appears that the person is being dealt with solely because they're part of that class, then we're going to be suspicious of that, and we're going to look to see whether or not discrimination has occurred. Okay. So initially the civil rights movement was for the most part talking about interaction between whites and African Americans and blacks. And the problem being, of course, a history of slavery. So for many years, the African Americans were not fully integrated and fully part of society. So in many instances, if you talked about, do you have past experience in this area? No, did not have past experience because we're enslaved. So that's kind of the place that we're coming from here. And so certainly race is one of our major protected categories. And we'll look at what the other categories that have been incorporated that also are people underrepresented or discriminated against in the past historically. Okay, now there's a whole string of laws, and again, there's a listing of these. There's 20, 30, 50 different laws that apply to these categories. And again, we're going to focus on what we believe to be the major laws that govern this area. So we're going to start with the Equal Pay Act. You can see that a number of these laws were in the 60s. A lot happened in the 60s in this area. And then we jumped to the 90s when we got the Disability Act. Okay, but start with the Equal Pay Act. Very important law next, the Civil Rights Act. And there's a particular part of that that covers employment, and that's the Title VII. So you'll hear that reference. We'll talk about age discrimination, and then we'll talk about Americans with disabilities. So these are some major statutes that cover this area, but a whole lot of additional laws hit different areas as well. Okay, so when we talk about Title VII, again, you will hear reference to Title VII probably more often than you hear them talk about Civil Rights Act itself. Title VII, every employer knows, is the employment law provisions of the Civil Rights Act. And again, Civil Rights Act, Americans with Disability Act, a number of these acts cover the other areas we talked about, public accommodation, state and federal, local government, etc. But this is the section of the Civil Rights Act covering employment, Title VII. So we'll refer to it that way. Okay. When you bring a claim under Title VII, you have to prove your case just like you would in any other kind of lawsuit. So the initial burden is on the person bringing the lawsuit, and we know that to be the plaintiff. So the plaintiff initially has to show a prima facie case. Again, Latin meaning showing on the face of the case. So we have to show that it appears that I have been discriminated against on the basis of one of these protected classes. Okay, and again, the laws are not job guarantees. They're just guarantees to be treated equally and not discriminated against on the basis of something of an illegal category. Okay, the way employers would protect themselves is obviously to treat everybody equally. So they would put in policies in place so that even the appearance of discriminating against somebody hopefully won't be there. Okay, the laws apply to hiring, promotion, discharge, compensation, all the basic terms of employment. So it's not just that you can't fire somebody. Obviously, if you never hire anybody from that race or gender, don't have to worry about firing. So these laws really cover the whole process of getting a job, advertising a job, interviewing, all of these different aspects. So it really wants to make sure that the people of all types have an equal opportunity to be hired and are going to be treated fairly. Okay, the first act that we want to look at, again, certainly not the first act at all, but a good starting place, is the Equal Pay Act. And this is on the basis of gender. And essentially what it's saying is that if you're performing the same kind of work in the same place, then you should be getting the same pay. Okay? Now, unfortunately, we know that despite this act, which has been around, 50 years, equal pay is not there. So again, there's some material on the website that talks about this, where we still have not achieved parity in wages between men and women doing the same job. Okay. Now, there are some defenses to having unequal pay, and that's if you're not doing the same work, obviously. So seniority, and again, a lot of union management contracts talk about seniority. Seniority is considered to be a relevant and appropriate factor for basing pay on. So if you can show that the difference in pay differential, is due to something other than sex discrimination, then you're covered. Okay. Okay, so again, just to look at this in general, and this kind of analysis applies to all the discrimination, but we'll use pay since that's where we started. You can see that we start out with a difference in pay, and the plaintiff would want to show that the difference in pay is due solely to sex. So you would attempt to negate or to show that none of the other factors apply. But if you look at the chart, you can see there's all different possibilities for why someone might receive different pay. Different market conditions, different companies, represented by different unions within a single employer, not actually doing the same work, etc. And the only one of these that really is going to be a violation is if you are being paid differently solely on the basis of discrimination, on the basis of sex. So again, the fact that you have a difference in pay, you still have the responsibility of showing that that difference is due to your status as a different gender. Okay, so let's look at the Civil Rights Act of 1964. Again, very major legislation, very broad. We'll be looking at the Title VII employer parts of it. And this indicates that the employer cannot discriminate on the basis of race, color, gender, religion, or national origin. So, not only is, although it came out of the civil rights movement, which we consider to be based on race, you can see race, color, national origin are there, but also it protects gender and religion. And as we indicated, it covers the full range of employment, the whole employment process, hiring, firing, training, discipline, benefits, etc. Okay, so Title VII prohibits discrimination, all the terms of conditions of employment, and it talks about two different types of discrimination. So we're talking about what we call disparate treatment. You're treating one of these categories differently, and we consider that to be kind of obvious discrimination. In other words, we are very clearly discriminating against a particular class. And then there's another area called disparate impact. In other words, something we're doing has the effect of discriminating or making less of a particular category. And this is kind of hidden discrimination, so it's not as apparent. So, again, disparate treatment is when we are intentionally paid less or treated differently. And so before the Rights Act, this was real clear. So you would have advertisements that said whites only, just like the swimming pool, or we only want men for this job, something of that kind. And so these would very clearly be disparate treatment. So we're treating somebody differently, and it's as we said, kind of obvious that that's what we're doing. Now, that's not going to happen much anymore after this act. It's not going to be that obvious. But a little harder to get our head around really is what we call the disparate impact. And what disparate impact means is that we're not being overt, we're not being obvious about our discrimination, but we have something in place that's having the effect of discriminating against one of these classes. So what might that look like? Well, we might have a rule that looks to be very neutral, so we can say, for this job, we only want people 6 feet tall. So, I mean, that can be like when you go to the amusement park, must be this high to ride this job. So there's a requirement there, and it doesn't appear to discriminate against a protected class because short people aren't a protected class. But is there any reason for that? If not, maybe we're going to be excluding a number of shorter ethnicities. So in Hawaii, the people over 6 feet likely to be Northern European or Sweden, and the people under more likely would be perhaps Filipino, Asian, or something else. So we might have a rule that sounds like it's neutral, but it has the effect of discriminating. Now, do we have a good reason for putting in 6 feet? Maybe yes, maybe no. And we'll talk about defenses in a minute, but that's what we mean, kind of a silly example of a disparate impact. We put a rule that looks to be neutral, but it's having a different effect. And then if so, we would need to show there's a good reason for that rule. Okay, Title VII coverage generally is going to be interstate commerce and having more than 15 employees. And this is going to be enforced by the EEOC, the Equal Employment Opportunities Commission. Okay, now we'll also, a little later, we're going to look at state law, and the state laws vary, and as we said, the state laws can provide more protection. And so, for example, in Hawaii, the Hawaii Employment Practices Act covers employers of any size. Any employer in Hawaii is covered by our employment law. And in addition to all of the categories that are in the Civil Rights Act, in other words, national origin, race, religion, color, gender, it also is going to cover 3 additional areas. So we're going to cover in Hawaii sexual orientation, marital status, and arrest and court record. And we have our equivalent of the EEOC, and that's the Hawaii Civil Rights Commission. And we'll talk a little bit more about this down the road. Okay, now when we have a claim, as we said, you have to prove your claim in discrimination just like you would any other kind of legal action. And again, we would bring it before the EEOC, so we would be, in that instance, a claimant at that point rather than a plaintiff in a lawsuit. And we would not become a plaintiff until we had completed our process with the EEOC, if necessary. So if we're fired or not hired or otherwise discriminated against, we do need to provide that prima facie case. So we need to show that up front it appears like discrimination has happened. Once we do that, once we've given a prima facie case, then the burden shifts over to the defendant to say, I had a good reason for what appears to be discrimination. So then it would shift over to them, I have a valid legal reason for what I did that appears to be discrimination. And if that's the case, it would shift back and we would need to show that defense doesn't apply, isn't real, or that's simply an excuse or a pretext that the discrimination is in fact occurring. Okay, so a prima facie case, really we have to show 4 things. We have to show that we're a member of the class. In other words, I'm a woman, I'm a person of color, I'm somebody with a disability, that I applied and was qualified for a job, but I wasn't hired or wasn't promoted, and that the employer continued to recruit or hire somebody of a different class. Okay, so this would be an instance, for example, you go to apply for a job, they've seen your resume, but you walk in and you can tell they didn't know that you were African American, and so they say, I just got a call, this job's been filled, sorry about that. And then later you find it wasn't filled, they hired somebody else that wasn't African American the next day. So now you have a prima facie case that looks like you're being discriminated against because of your ethnicity. Okay, particularly if we have a pattern of that, it's even more obvious. And of course, EEOC or Hawaii Civil Rights Commission is going to keep track of these sorts of things to see if there's some kind of pattern. But even not, you have now presented a prima facie case. And so it would go on the employer now to come up with a defense. So what could the defenses be? Well, some of these are regular types of defenses, but the ones that we want to look at that are new to us is bona fide occupational qualification. Okay, so what exactly is a bona fide occupational qualification? Well, bona fide is Latin meaning good, for real, in other words, genuine. And so that means that the qualification for this position, this is in fact a requirement of the position. It's part of what's necessary to be able to do this job, And so even though it may have a discriminatory impact, it is in fact okay. So what would be a good bona fide occupational qualification defense? Well, a kind of a simplistic example would be, what if we had a position that was assisting people when they went to visit their physician, dressing and undressing, getting into the hospital gown, that sort of thing. And so this was for a gynecologist, and we would say, for this position, assisting patients, we would like this is restricted to women. So we want a woman to assist other women to get dressed and undressed. So if it's something very intimate, personal care, disrobing, that sort of thing, we might make that qualification. Now, is this discriminating on the basis of gender? You bet. We're saying we only want women. So if I went down and said, whoa, sounds like a good job, I wouldn't mind doing that, then they would indicate to me, I'm sorry, this is for women only. Now, at that point, maybe I presented a prima facie case because they're obviously limiting it, they're excluding men, but do you think this would be a bona fide occupational qualification? You bet. Okay, so the court would say that's a good reason. That's a sensible reason. Be other examples when we talk a little later about religion, that sort of thing. So for many years, actually, Kamehameha School said we want our faculty to be Protestant. Okay, now they're basing discrimination on religion. Is there some reason that their faculty would need to be Protestant? Well, it turns out there wasn't. But what if, for example, a church says we want somebody to teach religion, we want somebody to teach catechism in our church? Would we be able to say that's a bona fide occupational qualification? Probably so. Somebody who's of a different religion or no religion wouldn't be able to do that. So that would be a bona fide occupational qualification, a BFOQ. So that's pretty generally a good defense if you can show that there is, in fact, a legitimate, good reason, sensible reason for having this particular restriction. Now, some areas, obviously, those were kind of clear. Some areas not so clear. So, for example, if we are having somebody portraying Princess Kailani in our movie, does it have to be Hawaiian or can we have somebody else? Well, latest movie had somebody from Peru. So, again, there may be some questions there, but some of them are clear, and that's certainly a defense if you can establish that there is, in fact, a legitimate reason for this kind of restriction. Okay, so what are the remedies under Title VII? Very substantial remedies. So the EEOC and or court can fashion almost any sorts of remedy: back pay, reinstatement, seniority, compensatory, punitive, attorney's fees, and injunctive relief. And we'll look briefly. Some of these were added to amendments to Title VII. They weren't back in the 60s. They've been added in 1991. But we have a full array of remedies here if, in fact, we find discrimination has occurred. Now, you can see we've added some remedies. There's reinstatement, but there's also various kinds of damages. And that's because if you've left a job, if you've been discriminated against, you may not want to go back to that job. So, for example, if you have been sexually harassed or otherwise mistreated, reinstatement's not a very good remedy for you. So in that case, you may do the damages and some of the other remedies. Okay, so let's talk a little bit about race, ethnicity, and origin, a major category and actually the impetus for passing the original Civil Rights Act in 1964. So again, all of the movement back in the early 60s was generally on the basis of race. But frankly, now that's not as big a deal in our civil rights problems because this has been around a while. People are not going to be overtly discriminatory very much anymore. Certainly in Hawaii, we don't see it much at all in an overt sense. And it's not really the area where we're having problems at this point. Now, there are occasionally things that come up. There was a suit a few years ago that had to do with some air traffic controllers, and they claimed they were being discriminated against because they were from the Philippines. So it was national origin, ethnicity defense. But as that one turned out, it was the reason that they were not being promoted, or the reason they were not being in certain positions, is because they had strong accents. And since English is the language of air traffic control, particularly speakers of other languages that were trying to communicate in English, for example, a Korean or Thai pilot was not able to understand the controllers. So even though it appeared that two or three were of a particular nationality, the reason that they were not being in those positions had to do with a necessary skill, a required skill, ability to be understood in English. So again, some of these come up, but it's not really the major area that we're looking at now in discrimination. Okay, how about religion? Okay, well, this is still a hot topic, and we still have a lot of issues coming up about religion. And again, even outside the employment area, we have prayer in school, separation of church and state, all of this sort of thing. But we have a fair number of these issues that still come up with respect to religion. And part of the issues that come up is what exactly is a religion, because we certainly have traditional religions, but now we have a number of other religious and spiritual views. And so there was even some controversy about when veterans have their headstones carved, what kind of symbols can they have on their headstones? Because previously there were 3 or 4 of the traditional religions that you could get a cross or a crescent or a Star of David. But if you were a Wiccan, in other words, a modern-day witch, you could not get that symbol on your headstone. So these types of things come up. So what are some of the issues that come up when we're dealing with employment? Well, a lot of it has to do with your work hours, your work schedule, what you're doing at work, obviously. And so there are both the day of that you celebrate your Sabbath or your day of worship. And so for some religions, that could be a Friday or a Saturday. And if that's a typical work day for the employer, they might be concerned that you're not available on that day. Okay, and again, holidays, same sort of thing. We don't have that many religious holidays anymore, but holiday obviously came from the word holy day. And so, again, this is whether or not you're able to work when the employer wants you to work. There may be some religious practices. In other words, there may be prayer during the day. There may be other things about how you prepare your food. There could be a number of other religious practices that might, from the employer's point of view, interfere with your ability to fit in and operate the way the employer likes to have things operate. There may be some religious clothing issue, and this can happen in prison and school, and it also can happen with your employment. So you may have ideas about modesty or head coverings or wearing a beard, turban, whatever, that may be contrary to what your employer, the public image or presentation they want. Okay. So these are some of the areas that you might have conflict or controversy that would be protected by religion. And the protection for religion is pretty strong. It's not absolute, so there can be certain things that the employer could require. But this is an area where generally you need to give a lot of leeway for someone's religious and strongly held views. Again, more discussion in detail in the materials. Okay, how about sex? Well, there's a lot happening in the sex discrimination area. We already have gotten a little bit of a head start on that when we looked at equal pay. Again, there are a number of issues that have to do with discrimination based on gender. It has to do with hiring and leave practices. So you've all heard when we're talking about, well, some people are on the job track and other people are on the mommy track, and we're concerned that if we hire somebody, eventually they're going to leave to have children, and so we will have put a lot of training in, et cetera, et cetera. So there certainly can be some discrimination in hiring people and in what the practices you have about leave, maternity leave, other types of leave. Okay. We've already hinted at the problems we have with salary advancement, the glass ceiling. Again, glass ceiling is just a word picture of being, this is as high as you can go. It's not in print any place. It's invisible, but we have people go up to vice president, and when we're looking for president, somehow it never is a woman. Okay, so that's what we mean by the glass ceiling. So there's certainly some issues there. As we've said, there still remains some pay disparity, despite the fact that the equal pay law has been in effect a long time. These child care issues, and a very hot issue here is pregnancy. So we'll talk a little bit more about that pregnancy discrimination, and this is both in hiring, etc. And this is an area that employers seem to be having a hard time with. It's still happening rather frequently with well-known large employers. We'll talk a little bit about that. Another major area is sexual harassment. So sexual harassment is in fact sex discrimination, and it can involve men against women, women against men, or same gender, same sex discrimination as well. And this is an area that there's a lot of concern with, and still a problem area as well. Okay. Now, looking at the sexual harassment piece of this, and again, we'll come back to the pregnancy area. Sexual harassment in the workplace involves sex, but it's more about the power. So there are two different kinds. One of them is kind of the more overt. So this is the harassment when you think of sex harassment, and this is where you're saying, go on a date with me or you'll lose your job or you won't be promoted, that sort of thing. So that's kind of a trade. That's the obvious kind. But there isn't another kind as well. So when we look at the two types of harassment, one of them is the quid pro quo. And for me, the Latin means something for something. Okay, and one of the somethings is having to do with your job, being hired, being advanced, getting benefits, and the other something has to do with sex. So it's date me, go to bed with me, something that has to do with sex. And it's a trade, it's an offer, and in essence, it's a coercion. So you are requesting somebody or directing somebody to do something, or it will have an impact on their job. So this kind of discrimination would be obviously by somebody who is in a supervisor's position or has some kind of control, or at least has some kind of appearance of control, that they would make this happen, or they could impact your job. So if it's somebody that's in a position inferior to you or same level and they couldn't really do this, it might not be taken seriously. And the other kind is less obvious, and this is what we call hostile working environment or hostile environment. And this is creating an atmosphere in the workplace that's offensive and hurtful and discomforting to someone. And this doesn't need to be a supervisor. So in the hostile environment discrimination, this can be virtually anybody doing that. So, for example, it could be another customer, it could be a supplier, it could be a coworker. Any of these people could be doing things that caused discomfort and was based on sex. And the employer can be liable even if they're not the ones doing it. So why would that be? Well, if they're in control of the situation and they don't do anything to change it, then that becomes their responsibility. Now, what exactly do we mean when we talk about a hostile working environment? Well, initially this came up largely in occupations that were traditionally one gender. In other words, certain industries only had men. For example, maybe mining, construction, for many years the military. All of these would be men. Of course, it could be a profession that was typically for women. For example, for many years, nursing. And maybe men had some issues when they went in. But again, this is where it started, and particularly when men were together, they would have gender-related jokes. They might have girly calendars or semi-nude or nude calendars. There would be other things that were available that made it uncomfortable, as well as perhaps intentional and overt comments about, what are you doing here? Why are you taking a job away from a man? Blah, blah, blah. So any of this could be creating an atmosphere where a worker was uncomfortable. Again, if the employer allows it, even if it's somebody not of the employer, then the employer can be responsible. And if, for example, if it's happening outside the employer's control, like you're having your delivery person is going to one of your customers and being harassed there, then again, you have control over the ability to schedule who goes there. You might need to take that into account as well. Now, how about people talk about, can this what if, you hug somebody or you put your hand on your shoulder? Is that harassment? Well, again, there's a common sense test here. So if you're in a firm where everybody at the end of the day hugs each other, or you give lays and kiss people, that sort of thing, is that harassment? Well, generally not if you didn't know that it was offensive touching, okay? But if you know somebody doesn't like to have that kind of intimacy and you keep doing it, then of course you move into the area that is harassment. But the first time, no, a common sense test. Okay, so how do employers cover themselves for this, since they could be responsible for the actions of both their employees and people that aren't their employees? Well, better practice is to put things into place. So to have a policy, make sure everybody knows the policy. If you need to have training about what constitutes harassment, that kind of thing. Because, again, you have people that are carrying it to the illogical extreme, and they're making a comment, perhaps, you look nice today. Is that harassment? Or if you make comments about what people are wearing. So you need to probably train your employees, particularly if you're in one of the professions that typically has not had a lot of both genders. Okay, then you would need to have provisions for if harassment claims come up, how do you handle those? Do you take them seriously? Do you do an investigation? Obviously, if it's a claim of a supervisor harassing somebody, for example, the quid pro quo, trying to get me to do something kind of harassment, then you'd have to have some kind of investigation that didn't have that supervisor as part of the authority chain. You would need to have someone else looking at that. And then you would, again, need to take it seriously and take remedial measures if you see something happening that's improper. Okay, as I said, the Civil Rights Act of 91 did some amendments, and this is where we added a number of additional remedies, including punitive damages, allowing jury trials, attorney's fees. So this expanded both the Title VII original Civil Rights Act and also the Americans with Disability Act that we'll talk about shortly. Okay, how about age discrimination? So how old do you have to be before you could bring an age discrimination suit, do you think? So you have to be senior age, retirement age. How old would you have to be discriminated against? Well, in actuality, under the Age Discrimination Act, you only have to be 40. So if you're 40 or older, then you may be able to bring an age discrimination suit. So actually, this happened in instances where, for example, the airlines originally, back when we called the attendant stewardesses, they wanted attractive young ladies. And so a number of suits were brought both by men who said there's no reason that an attendant has to be a woman, and again, women that would sort of age out and not be the persona that the airlines wanted to have, and so they would be fired because they were getting older. And both of those types of claims were found valid, and that's why we have attendants and we have older attendants, both men and women. Okay, and now the big area in our major law is the ADA, the Americans with Disabilities Act. And this was in 1990, so we've had 20 years of experience. This was a major, major act because you wonder why we had all of these acts in the 60s, and then it took, 25 years before we got to disability. And that's actually because the disability community was very, very diverse. We had people that had physical disabilities, sight-impaired, blind, mobility issues, back when we called people handicapped. We no longer use that except for the stall now. But it took a while for everybody to kind of coalesce and together put this together. And it covers not only physical disabilities, but it also covers mental and emotional disabilities. So again, a major act. It prohibits employer discrimination against qualified individuals who, with or without reasonable accommodation, an important word, can perform essential functions of a job. And a major amendment in 2008. So Americans with Disability amendments. So what is a disability? Well, it's somebody that has a mental or physical condition that substantially limits one of life's major functions, or a record of an impairment, or regarded by others as having. And this is going to be very broadly interpreted. And again, the amendments a few years ago made this clear that we want a very broad definition of who's disabled. Okay, it applies to private employers with 15 employees, public employees of any size, and the part of the ADA that concerns employment is Title I. So just like the Civil Rights Act and the other things we've looked at, the ADA covers accommodations, state and government, etc. And the part that covers employment is Title I. So it's Title I of ADA that we're concerned with. When we talk about accommodation, we mean what the employer needs to do to give a reasonable opportunity to someone with a disability that's otherwise qualified. So this is not a required to hire people with disabilities act. It's required to give them an equal opportunity to be able to do the job. In other words, to be able to do the essential functions of the job. So we're not going to require you to hire someone that cannot do the job. Now, you do need to provide reasonable accommodations, and we'll talk about what those are. But if the hiring would cause you an undue hardship, put you out of business, put you at risk, etc., then you are not required to do that. So again, common sense. Okay, so what could be some accommodations? Well, it might be modifying the work area. And in the public arena, you've seen this where we do wheelchair ramps, we lower down teller stations and water fountains and things to make sure that people can get access to them. We might change the arrangement of the office, make sure there's enough room for a wheelchair, that sort of thing. So these are kind of the obvious ones. We might have assistive technology, in other words, where the computer will speak if you're sight impaired, or we might have the TTS phones where if you're deaf, it texts out what the person's saying. We might need to have different assignment of job functions. For example, if you are in a job, you're at your desk, you're in a wheelchair, but every now and then you would need to get printer paper that's a different place. Rarely need to do it. That easily could be assigned to someone else, not a major part of that job. Okay, I'd like to talk a little bit about state law now, because we recall that state law has provisions in addition to what's covered by the Civil Rights Act and the other federal acts. And these are again handled by the Civil Rights Commission, which is our equivalent of EEOC. So if you recall what the additions that we have in our employment law, and again, our law applies to employers of any size, and we're going to protect sexual orientation, marital status, and arrest and court records. So a Hawaii employer has to cover this. Federal employer does not. And again, the easy example here is federally in the military, we still have don't ask, don't tell, where discrimination against people on the basis of being gay is possible. That isn't possible by Hawaii employers because sexual orientation is covered. And the Hawaii Civil Rights Commission has also said that applies to transgendered, bisexual folks as well. So that's covered by our state law. Now, there's been a lot of pregnancy discrimination, and there are some materials on the website about some cases that involve pregnancy discrimination. Again, there's an increasing number of suits, and the Hawaii Civil Rights Commission has actually produced a CD for employers to go over this. And why is pregnancy discrimination a problem? just a guess, but it appears to be that employers think, well, this is a voluntary act. You decided to get pregnant, so that's something you decided. It's not a condition like being African American or whatever. But when you think about it, as far as we know, only women get pregnant, so this is clearly sex discrimination. Okay, just the last thing I'd want to cover is just all of these areas will come up when you're getting employed. So an employer needs to be careful when they ask questions. Certain questions are going to be just flat illegal. And that's basically the ADA is not going to allow you to delve into somebody's personal medical history, work comp history, that sort of thing. You can't ask those questions till after you've hired. But there are a number of other areas that you're not prohibited from asking questions, but it's a real bad idea if you're an employer. So you don't want to ask about these protected categories. Why? Because it's going to appear that if you don't hire the person, it's going to sound like that may be the basis. So let's just quickly look at some possibilities how you would handle this. Okay, so if you ask what nationality or ancestry are you, or are you a U.S. citizen, what's the purpose of that question? What has that got to do with how to do the job? Now, can you get some of this information? Well, you could ask about language if it's part of the job. You could ask about are you lawfully able to work, because this is an Immigration Reform Act question. You do need to be legally able to work. Those are appropriate, but asking these other questions can get you in trouble. What's your maiden name? What's your spouse's name? How old are your kids? Are you pregnant? Again, not illegal to ask them, but a bad idea, because if you then refuse to hire, then there's certainly the person might be able to make a prima facie case. Why did they ask me that? And then they didn't hire me. So you can get at that different ways sometimes, but some of it's just flat inappropriate. You can certainly ask about work availability. Now, the reason they might not be available might be religion, might be children, might be something else, but in essence, you shouldn't care. You just want to know, are they available? Okay. And these are clearly improper questions when you ask about health and disabilities. This is just flat illegal under ADA. But you can ask, are you able to do X? Okay. So you can see interview questions are not as simple as you would think. If you've got an HR department, great. If not, probably ought to do a little looking to make sure that you're asking appropriate questions and not setting yourself up. Okay, well, we took a look now at how the employer-employee relationship went, what your duties, responsibilities, rights are as an employee. And next time we're going to take a look at setting up your own business. So we'll look at the various types of organizations, sole proprietorship, and then we'll continue on and look at partnerships, corporations. So we'll look at the mechanics of how to set that business up. So I will see you next time. Happy reading, etc. Aloha.